Rosa could potentially bring a claim in negligence against her employer, the Tate Gallery, the churches she volunteered, as well as Mr. Ken, her doctor, who made the diagnosis. All cases have no issue of remoteness, as exposure to atrium is accepted to increase the chance of developing the cancer, while a wrong diagnosis decreases the chance of survival by having late treatment of the cancer. They are reasonably foreseeable in these cases. Firstly, Rosa worked in Tate Gallery and several churches where atrium was used. The only difference is that Rosa gets paid in Tate Gallery while she volunteered in churches. Knowing the risk that exposure to atrium could increase the chance of developing the cancer, a presumption duty of care shown in Fairchild is that employer is to take reasonable care or to take all practicable measures to prevent Rosa inhaling atrium. This duty of care is also the same for the churches according to the Health and Safety at Work Act. However, we don't know whether Tate Gallery or those churches have provided all means to prevent the exposure to atrium during the working period. We need more information in this. Rosa should be aware that both parties may not be liable if they did provide full and effective measurements as they have done their duty. Only if not, they will be possibly liable as by breaching this duty of care, Rosa will have been directly exposed to atrium and likely increased chance of developing the cancer, and therefore they will be said to have materially increased the risk of developing the cancer. However, we cannot conclude that who is liable for all causes or who contributed more in increasing the risk of developing the cancer. Rosa has already exposed to atrium when she volunteered in churches before taking the job in Tate Gallery, and she has been using atrium for her own personal art projects. Tate Gallery will of course argue that the churches or Rosa herself, solely or mainly, materially contributed increasing the risk of developing the cancer, so he will not be liable, or the compensation should be apportioned equally or accordingly between two of them. Yet, Tate Gallery wishes to argue this. The burden of proof lies to him. However, in fact, this is not possible as it is unknown whether the cancer developed as a result of cumulative exposure over long period of time or whether a single exposure is all that is needed. Therefore, all of them, including Rosa herself, will be possibly liable for the cause of cancer, according to the case Barker. Nevertheless, the churches will argue that Rosa voluntarily applied for help in the churches, and the mere fact that Rosa goes to work every day knowing that her workplace is not reasonably safe place to work in would establish that Rosa is willing to work for the churches knowing that it is unsafe, which is supported by McCafferty. Therefore, they will argue that Rosa should be liable for the cause of cancer. Apart from that, Tate Gallery will also argue on this basis that Rosa consented to have working in a place knowing that it is not safe to work in, but she still chose to get the job. However, both Tate Gallery and those churches would unlikely succeed with their argument, especially when it comes to our employer-employee context, and noted that a mere knowledge of the harm is not sufficient. Rosa may not be fully informed by her employer, and although she volunteered in churches, this doesn't mean she fully consented to take the risk of developing a cancer, as in the case of Smith. If their defenses were available here, their duty of care as employer and voluntary organizations would be meaningless. Instead, Tate Gallery and the churches would rely on contributory negligence, which is splitting Rosa's damage between them, including Rosa herself, as she has also used atrium outside her jobs. While we don't know whether Rosa has taken any effective means to prevent inhalation of atrium, if she did not, they will more likely be jointly liable, and the damages payable to Rosa were liable to reduce for contributory negligence, shown by case Lane. However, the issue is how much to blame were Tate Gallery and the churches together for the harm suffered by Rosa. The court will look at the contribution of both parties to the harm suffered by Rosa and apportion a percentage of responsibility to each party. Yet, again, it is unknown how the cancer develops as a result. Therefore, it is likely that the damages will apportion equally between three of them. However, the law now and the Compensation Act indicated that in case of evidential uncertainties, although Rosa used Atrium herself outside the jobs, her employer would still be liable for the full compensation as long as Rosa could satisfy the court that the increase in risk caused was material, even when the lung cancer was attributable to only one negligent source, supported by the case seen Kiwis. The only way an employer could moderate his liability would be either showing that the amount of atrium to which he exposed to Rosa was so small that it exposed Rosa to an insignificant or de minimis risk of developing the lung cancer. Another way is to show that Rosa deliberately and culpably exposed himself to atrium, but we don't know about it. So all in all, Rosa could have a negligent claim against Tate Gallery and the churches, but the damages that she can claim depends on the court's decision. Secondly, speaking of Mr. Can, who has a doctor-patient relationship between Rosa. Mr. Can has presumably owed Rosa a duty of care in relation to his diagnosis and subsequent treatment which would follow. The case that Mr. Kent is a breathing specialist, the standard of care is altered to take account of the professional status of Mr. Kent, as in Bolam, regardless of his level of experience. Therefore, the question is simply whether a reasonable breathing specialist would have diagnosed with asthma, though we need more information in this, but we are told that Mr. Kent had wrongfully diagnosed Rosa's situation 3 years ago as asthma, but instead a lung cancer, and this has decreased her chance of survival. It implies that Mr. Kent breached his standard duty of care. On this basis, Rosa could have potentially claimed for the loss of chance against Mr. Khan, but however, this highly depends on the exact percentage of the chance of survival if Mr. Khan had made the correct diagnosis. If Rosa has only below 50% chance of avoiding developing the cancer, she would not be she would not able to argue that Mr. Khan's negligence caused her to develop the cancer, because it was more likely than not that she will still develop the lung cancer even had Mr. Khan had treated him properly, so she will less likely to be succeed for the negligent claim. In contrast, if Rosa has more than 50% chance of avoiding developing the cancer, she will be liable to claim full compensation from Mr. Khan for the fact that she developed a lung cancer, and arguing that it was more likely than not that had Mr. Khan had not been negligent, she would not have developed the lung cancer, so Mr. Khan's negligence caused her to develop the cancer. However, we need more information in this, as we do not know the exact percentage of the chance of survival. We only know that it was between 45 and 55%. To conclude, a higher chance of survival, which is more than 50%, would likely bring a successful claim. Let's say if Mr. Khan is liable for the negligence, he will argue that where the medical community informs that exposure to atrium could cause cancer, Rosa still chose to work and use it voluntarily that put her in a position whereby he needed treatment, and therefore this behavior this behavior makes her contributory negligent, so Rosa should also be partly liable for the causes. However, the case St. George illustrated that this was a lifestyle choice made prior to the creation of the duty of care of Mr. Khan, so it cannot be considered for the purposes of reducing any compensation. Therefore, whether Rosa could bring a successful negligent claim against Mr. Khan depends on the time if Mr. Khan had correctly diagnosed Rosa's condition in the first place. What is the exact percentage of the chance of survival should first be asked.